Hello everyone, I am Shashank and you're watching iSharky. So guys, in today's video, we are going to discuss Article 17 and Article 18, which is Abolition of Untouchability, and Article 18, Abolition of Titles. So here we will going to discuss these articles in a very simple manner, so you can get maximum in your minimum time. Before moving on, make sure if you haven't watched my previous videos of Article 14, 15 and 16, all the links are given in the description. After watching this video, please make sure to watch them also. So let's get started. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability is to be an offense punishable in accordance with law. In exercise of powers conferred by Article 17, Parliament has enacted the Untouchability Act 1955. This act was amended by Untouchability Amendment Act 1976 in order to make the law more stringent to remove untouchability from the society. It stands renamed as the Protection of Civil Rights Act 1955. Under the amended act, any discrimination on grounds of untouchability will be considered as an offense. It imposes a duty on public servants to investigate such offenses. It provides that if a public servant willfully neglects the investigation of any offence punishable under this act, he shall be deemed to have abated an offence punishable under this act. The Protections of Civil Rights Act prescribes punishment which may be extended to imprisonment up to 6 months and also with a fine which may extend to 500 rupees or both for any one enforcing. On the grounds of untouchability, religious disabilities like preventing any person from entering any place of public worship or from worshipping or offering prayers therein, or social disabilities like access to any shop, public restaurants, hotels or places of public entertainment, and refusing to admit persons to hospitals and refusing to sell goods or render services to any person, or for other offences arising out of untouchability. The fundamental right under Article 17. In Asiad Project Workers case, the Supreme Court held that the fundamental right under Article 17 is available against private individuals, and it is constitutional duty of the state to take necessary steps to see that these fundamental rights are not violated. In State of Karnataka versus Appa Balu Ingale, the respondents were tried for offences under Sections 4 and 7 of the Protections of Civil Rights Act 1955 and convicted and sentenced to undergo simple imprisonment for 1 month and a fine of ₹100 each. The charge against the respondents was that they restrained the complainant party by show of force from taking water from a newly dug up tube well on the ground that they were untouchables. The High Court acquitted them. The Supreme Court upheld the conviction. The court held that the object of Article 17 and the Act is to liberate the society from blind and ritualistic adherence and traditional beliefs which have lost all legal and normal base. It seeks to establish new ideas for society like equality to the Dalits at par with general public, absence of disabilities, restrictions or prohibition on grounds of caste or religion. So, Article 17 is complete. Now let's talk about Article 18, which is Abolition of Titles. It prohibits the state from conferring titles on anybody, whether a citizen or a non-citizen. Military and academic distinctions are, however, exempted from the prohibition, for they are incentive to further efforts in the perfections of military power of state necessary for its existence and for the scientific endeavors so necessary for its prosperity. Article 18, Clause 2 prohibits a citizen of India from accepting any title from any foreign state. Article 18, Clause 3 provides that a foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. Article 18, Clause 4 avoids that no person holding any office of profit or trust under the state shall accept, without the consent of President, any present, emolument or office of any kind from or under any foreign state. The conferment of titles of Bharat Ratna, Padma Vibhushan, Padma Bhushan or Padma Shri, etc. are not prohibited under Article 18, as they merely denote state recognition of good work by citizens in the various fields of activity. These awards seem to fit in within the category of academic distinction. These national awards are given in recognition of exceptional and distinguished services of high integrity in any field. It is to be noted that there is no penalty prescribed for infringement of above prohibition. Article 18 is merely directory. It is, however, open to Parliament to make a law for dealing with such persons who accept a title in violation of prohibition prescribed in Article 18. No such law has been passed by Parliament so far. Now let's take a case law. In Balaji Raghavan versus Union of India, the petitioners challenged the validity of these awards and requested the court to prevent the Government of India from conferring these awards. It was contended that these awards are titled within the meaning of Article 18. It was also argued that these awards are being grossly misused and the purpose for which they were instituted has been diluted and they are granted to persons which do not deserve them. Awards such as Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri are not violative of principle of equality as guaranteed by provisions of the Constitution. These awards do not amount to titles within the meaning of Article 18, which are not violative of Article 18 of the Constitution. The theory of equality does not mandate that merit should not be recognized. Article 51A of the Constitution speaks of the fundamental duties of every citizen of India. In view of Clause F of Article 51A, it is necessary that there should be a system of award and decorations to recognize excellence in performance of the duties. However, the court criticized the government for its failure in exercising sufficient restraint in the conferment of these awards. The court said that guidelines contained in the communique from the Ministry of Home Affairs towards the selection of probable recipients are extremely wide, imprecise, amenable to abuse, and wholly unsatisfactory for the important objective that they seek to achieve. The court suggested that a high-level committee may be appointed by the Prime Minister in consultation with the President of India to look into the matter. The judges made it clear that the committee may keep in view the anxiety of the court that the number of awards should not be so large as to dilute their value. So guys, Article 17 and Article 18, which are the fundamental rights, are completed. I hope you enjoyed the video, and if you learn anything new from this video, please make sure to like and share this video also. And also subscribe this channel and also press the bell icon. My next video will be on right to freedom, which is Article 19. And also don't forget to watch my earlier videos like Article 14, 15 and 16 are there in the description. Please go and watch them also. Thanks for watching.